Court come to order. Please be seated.
You're going to be giving the closing for the state?
It would appear so, Your Honor.
All right.
I do believe Clint Rucker was about to come. It was my understanding he was outside. Could I check to see? And if not, I will proceed with the state's.
That would be great. Thank you.
Sorry, Judge McBurney.
No problem. When you're ready, I am ready to hear your synthesis of everything that's been presented. So you can tell me what you think I ought to do, then I'll hear from the defense and I'll let you wrap up.
Okay. Just give me about 30 seconds to catch my breath, and then I'm ready to go.
Okay.
All right. Okay. Good afternoon, Judge.
Good afternoon.
And let me first tell you, thank you so much for just granting me a few minutes to get here and to catch my breath, collect a couple of thoughts. But I do want to address the court about a very serious matter. My plea to the court is that you would find that Claude Lee McIver III has intentionally violated a court order and revoke his bond. Because I believe that the evidence that's been presented by the state proves that the defendant intentionally disregarded court's orders, that his actions create a tremendous safety concern that makes him dangerous to others and the community. And I believe that the evidence has shown that when he got caught, he unlawfully influenced witnesses. And what I would contend at this point, the court could conclude, is tantamount to a conspiracy to cover up the truth. To tamper with evidence and to obstruct the fair administration of justice that the law requires. I know the court is very, very aware of the Supreme Court case Ayala versus the state. For the court reporter, the site is 262 Georgia 704. It outlines very clearly the things that the court ought to look at when considering whether or not a defendant meets the requirements to be eligible for a bond, to be allowed to be freed from custody such that they do not pose a flight risk, such that they do not pose a danger to the community and others, such that they do not do anything to interfere with the fair administration of justice. And I would report to the court that I don't believe that that is the case for Mr. McIver. I'll start here. Judge, first of all, we know that there are two court orders. Court orders very clearly say no guns. Mr. McIver knew this, and everyone else around him knew this. And that's pretty important because as the court has heard the testimony from some of these witnesses who are very, very close to him, there really is no good explanation about why this man has a gun in his sock drawer. And, you know, you have to ask yourself the question, why would he have a gun? After all that we know has happened, why would he have a gun? And I'm going to tell you, Judge, what you can infer from some of the evidence. It's because he is infatuated with guns. He loves guns. Howard Seals got over 20 guns in his possession that was turned over to him by the defendant. But I'll tell you what's very, very interesting. Jenny Calhoun says, look, when I looked in the condo downtown, right across the street from Lenny Square Mall, he had 5 handguns and 1 rifle. And the thing that kind of gave me the inkling about this infatuation was this. Jenny Calhoun said, listen, we went through the house. We searched high and low everywhere. We wanted to take the guns out of the condo because we were concerned about Mr. McIver's state of mind. That's what they said. And then she said, you know what? He came to me a little while later. He said, hey, I'm okay. I want my guns back. After, while holding the gun, he shoots and kills his wife. Why? Why? It's because he loves her. Now, let me tell you just a couple of basic facts. One, we executed a search warrant on April the 14th, 2017. This is a critical word I'm going to ask you to think about. It was a surprise. It was a surprise, which means the defendant had no time to hide the gun. Nobody knew we were coming. And when we got there, we recovered the gun from a private, secure place. You just got to use your common sense. They got 3 levels of security before you even get in the building. Video cameras everywhere, which I'm going to speak to that a little bit more in a minute as it relates to James Hugh. But video cameras everywhere. You got codes to get in the condo, keys to get in the condo. Not but a few people on the planet has access to this place. It's in a closet where his ties are hung, where he keeps his underwear, in a drawer underneath some socks. I mean, if you were going to hide something, I mean, that's pretty much where you put it. And it's no secret to me, I don't think it's a coincidence, that in the drawer right above it, we find bullets that are the same caliber as the gun that we find in the drawer below. That's not a coincidence. Another fact, the defendant knew that we found the gun on Friday night. That's very, very important. Because when I talked to the court about the unlawful influencing of witnesses, it kind of started, in my opinion, right then. Because what we have at that point is Tammy Johnson becomes a mole. She is a part of this, what I will call a cover-up. She had our phone number. If there was a problem and she was concerned, we asked her, don't get in it. Stay out of it. I contend to you that Mr. Abadi was even more direct. Don't mess with the gun. We got along with Tammy. There were no problems there. We didn't want her involved in this. And that's what we told her. But instead, this is what she did. When she said something very, very key, I think. Janie Calhoun says, listen, when she came over to talk to me after y'all left, this is what she said. Well, the DA's office told me to stay out of it, but I'm going to go and get the gun anyway. Anyway. And the reason why she said that is because she had already had a conversation with Mr. Maples. And what we learned, not from Ms. Johnson, but from Janie Calhoun, is that there were lots of conversations that she didn't share with us that took place in the apartment of Ms. Calhoun. Now we know that they actually reached out to Tex McIver. Janie Calhoun says, hey, I called Ann Swall. They were at a ball game for Austin. We were trying to find Tex. We had to tell him. We talked to Tex. He was crying. He was crying because he was caught. And we know that what they decided to do is call Howard Seal, all the way in Putnam County, to ask them if it was okay for Tammy to take the gun out the building because she didn't have a permit. These people weren't talking about doing the right thing. They were talking about secreting this gun. And how do you know they were talking about secreting the gun? Because had I not asked her about it, almost 6 days later, she would have never mentioned it. She had many opportunities. She spoke to Investigator Griffin on Monday. She didn't say nothing about the gun. She broke her appointment with us, though. She hired a criminal defense lawyer, one of the best in the city. Why? Why? They don't tell us they got the gun on Monday. They don't tell us they got the gun on Tuesday. They talked to me many times over the course of those couple of days. We exchanged a bunch of emails. Never said a word. I'm still looking for the gun. Wednesday, they come in here, strolling in my office, sit down. We get 30 minutes into the interview, and I kind of say to her, hey, we went back out to the condo. The gun is gone. Do you know where it is? Oh, I took it. What? It's just not right. And I'll tell you something else. Tammy Johnson has been dishonest with the court. She's been dishonest with the court. Did I have, one scoop of ice cream or two? Okay, that's one thing. But listen, now what we know, she represented to all of us on Friday this notion that she really didn't communicate with Mr. Maples on Friday. Like, I talked to him once. And I really didn't communicate with Tex McIver about this. And there really wasn't a whole lot of contact about this. Like, I pretty much made these decisions about taking and hiding the gun all on my own. I had to go get her phone records to confront her with her phone records. And now what we know is there were many, many phone calls going on back and forth between Tammy Johnson, Tex McIver, and Steve Maples. What were they talking about? What were they talking about? And what I wanted her to tell us was the truth about the substance of the conversations that they were having. Because I believe they were talking about things that affect his condition for bond. They were trying to figure out how in the world are we going to get out of this. Because he knew he had intentionally violated that condition. And he didn't want to go back to jail. I believe those conversations will prove that the defendant had knowledge, and I think those conversations contain incriminating statements. That's really the only motivation for her to be dishonest with the court while under oath, doing an official judicial proceeding about those conversations. And it's not even just big things, it's little things. Like I asked her, hey, did you talk to Howard Seal? No. I only sent him text messages with pictures of the phone. Then Janie Calhoun comes in here and says, oh yeah, we called Howard Seal on Friday night. He told Tammy it was okay, she could take the gun as long as she didn't have it concealed. She looked me in the face, she looked you in the face, she was dishonest. And it's not right. And as I stated to the court in the presence of Mr. Latito, there could be charges coming down the pipe for Ms. Johnson. I would submit to the court that by instructing Tammy to move, touch, and hide the gun, that Mr. Maples and Mr. McIver, who are both attorneys and members of the bar, caused potentially vital evidence to be destroyed. Because of what they told Tammy Johnson to do, there's no chance for us to check for fingerprints, which could prove whether or not Mr. McIver actually knew about this gun, had this gun, or touched this gun. The opportunity to do that is gone. That is tampering. How about these shot bullets? Maybe bullets in and of themselves. Might not be a whole lot. But you know, when you got bullets that match the caliber of a gun found in a sock drawer that you're not supposed to have, I would say to the court that's not coincidence. And the thing is that some of the bullets were missing from the pack, so they had been fired. You can't fire 9mm bullets in a .38. You can only fire them in a 9mm. And the expert told us that these are ammunition. They're not pellets. They're ammunition. And you know, one of the things that has been suggested is that because they're pellets, you know, Mr. Hill got up and said, hey, from me to you is dust. It's no big deal. And they're really used to kind of shoot small animals and that kind of stuff. Well, I would submit to the court, you know, things kind of come together in cases like this. You know, you put these little pieces together. It's like putting together a little puzzle. So, you know, probably those kind of bullets are used to shoot like buzzards. You know? Which, by the way, I found out, didn't notice till last night when I looked it up. Buzzards are a federally protected animal. It's actually a federal crime to kill a buzzard. But buzzard shooting is really just evidence that shows that the defendant has bad judgment when he has access to guns. It was to show the court that he did this through a screen in the presence of a little bitty boy, his wife, and Jenny Calhoun. Just kind of whimsical, on the spur of the moment, it just doesn't make no sense. There's no telling where them pellets or that bullet could have landed. I invite the court to write this down. It comes from the state of Georgia bar rules, rule 3.4. 3.4 is titled Fairness to Opposing Party and Counsel. A lawyer shall not unlawfully obstruct another party's access to evidence, or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. And the lawyer shall not counsel or assist another person to do any such act. They know better. Judge, they know better. And the only logical reason why they would go to such extent is because Mr. McIver is guilty. He is guilty of violating the court's order, knowingly, willingly, and intentionally. Very, very briefly, some facts. We know that the DA's office got a warrant on Friday. We executed on Friday. Gave no notice to the defendant. We know that Tammy is the manager of the victim's estate. And I want to point that out to you. Technically, she works for, or supposed to work for, the estate of Diane McIver. Look out for her best interests. But it appears to me to be an obvious conflict. And if it's not a conflict, this show is fuzzy. Because she is paid based on the actions of the executor of Diane's estate, who is the defendant. So who are you really working for? If your $5,000 a month depends on Mr. McIver. And listen, she is the kind of person who was hired to be meticulous about this, to make very specific records, have a great memory with respect to the thousands of pieces of Diane's property that she is responsible for. And if she comes in here and she can't remember how many phone calls she had with this man sitting over here about a gun found in his sock drawer after the passage of 1 week, it's incredulous. And it's not right. We know that she talked to Mr. Maples after she found the gun on Friday. We know that Mr. Maples tells her to get the gun out the house on Friday, tells her to take it to Janie Calhoun's house. So what we have is this cascading conduct that improperly and impermissibly influences witnesses. So based on the actions of Mr. Maples and Mr. McIver, now Tammy Johnson is influenced. Now I got Janie Calhoun, she's influenced. Now Howard Seals, he's involved, he's influenced. Oh, what a tangled web we weave. We know that Mr. McIver knew about the gun on Friday. We know about the phone call to Howard Seal. We know what Howard Seal tells her, it's okay to move the gun. She puts it in a suitcase, takes it to her daughter's house, sneaking around her daughter's house, hiding the gun in the bathroom so won't nobody know that she's got the gun so she can take pictures of it and send it to Howard Seal. Why would you do that? It's because you know you ain't got no business with this gun. Got all these phone calls between the parties over the weekend. Why can't she just tell us the truth about what they talked about? We told her to stay out of this situation. She didn't come see me on Monday, didn't mention nothing about the gun. Got a defense attorney who actually, ironically, or maybe not so much so, works in the same office as the estate attorney for Diane McIver. That wasn't lost on me either. Why is this legal shield being put up? It is done for the benefit of the defendant. We know that Tammy done tell Investigator Griffin about the gun on Monday. And by the time she gets to me on Wednesday, you know, the gun is down in the trunk of the car. I got to send somebody down there to go get it. And it doesn't even have all the pieces to it because she still got the magazine somewhere in a luggage or purse or somewhere. Now, I'm about to take my seat. But I want to close out by talking to you about something that I think is really, really bad. It's really, really bad. And I say it's really, really bad because it really speaks to the desperation of the defendant. They have insinuated, they have suggested, and they have implied that others have planted this gun in an attempt to get Mr. McIver in trouble.
I don't know that it was an insinuation, but it's certainly out there.
And they did it by asking questions that would lead a reasonable person to believe that Billy Corey is somehow a mastermind who, I guess through some magical crystal ball, knew that we were going to execute a search warrant on Friday at his condominium. And somehow either himself, you know, at 80-something plus years old, was able to get access to the condo and bring this gun with him, which, by the way, was actually purchased by Mr. McIver's brother. I'm going to talk to you about that in a minute. And I guess the brother's in on the conspiracy too. And take this gun and tiptoe through to the closet and put it in the sock drawer and get away, before we arrive. That wasn't going too well with them, and they got a problem with that. And the problem with that is, this is what your common sense tells you, right? Is that Mr. Corey was given a gun that's almost identical, except for color. And the gun that he was given, it was given in the box that goes with the gun that we found in the condo. And the only connection between the two is the defendant. And that's a real problem for them. They can get up in here, they can kind of wave their hands and try to make fun if they want to. That is a real problem for them. Because it limits, you see, who would have access to the other gun and the other box. So what they did was, when Mr. Corey's thing wasn't kind of working out for him, then they started talking about James Hugh. Start throwing his name out there. Well, James Hugh could change the combination on the door. And James Hugh could come and go like he wanted to. And James Hugh works for Mr. Corey, and it really has an alignment with Mr. Corey. When the truth of the matter is, James Hugh loved Diane McIver. He had known her for 30 years. And the truth is, he loved E.D. Tex. Perhaps before yesterday, when he found out that his name was being put in something that he had nothing to do with. And I'm going to tell you something. I asked Adam about it. I said, ask him why he is getting so emotional now. And he really couldn't explain it to you. I think he's hurt so bad. We asked you to come down here. Why didn't you come down here? Oh, you avoiding us. You signed with the DA. Oh, this is all just one big conspiracy. And that man sat there and he almost broke down and started crying. I know you saw him. Why? Why? It's because he would believe that Tex McIver would stoop so low as to try to throw him under the bus like that. He said he loved Tex. He would never do anything to hurt him. And you could tell by his demeanor in court, you can believe him. He had no reason to do it. He had no access to do it. And this is the thing that I thought was real interesting, Judge, that these lawyers ought to be shamed. They cross-examined Mr. Hugh and they asked him, hey, we see you on the video. We see you coming into the condo. We see you leaving. You're gone for a couple of hours. I guess you was washing the car. We see you come back. We see you leaving. Let me tell you something. If he was carrying the black box, you better believe you would have seen it. But the reason why you didn't see it is because he wasn't carrying the black box. They were just trying to draw in the inference that he had done something wrong. In some of my closing arguments, I call that muddy water. Designed to deflect away from what is really the truth. He won't never get it, but truth be told, they owe Billy Corey an apology, and they doggone sure owe James Hugh an apology. Questioning that man, they knew that was a lie because they had the video to prove it. Now, we know now that the defendant and Diane gave Billy Corey the exact model gun as the one that was found in the sock drawer. The boxes were switched, and I contend that's like breadcrumbs really leading you to the truth. Because what we did was we were able to check with the ATF, that's the Alcohol, Tobacco, and Firearms Division of the federal government. They keep track of guns. And if you give them the serial number on the gun, they can kind of track it all the way back to the beginning and tell you where it went from the time it left the manufacturer. And this is what we know. We know that based on this report, the defendant knew where this gun came from. I understand about defense counsel's arguments when they get up and tell the court, he didn't know. He didn't know. He didn't know. I guess the gun dropped down from outer space from some Martians and landed up in the sock drawer. But that is disingenuous, Judge. And up until the point in time that I actually showed them the ATF report, they were traveling under the theory that somebody else had planted it. And the court can take everything into consideration, and so I know you know this. They asked me for that ATF report a long time ago, and I didn't give it to them. Strategically so. Wanted to see if they were going to throw John Rogers McIver under the bus, his own brother. They never even mentioned him. But he's the one that bought the gun. They called him Spike. Boy. The court has been doing this a long time. My argument to you would be that, you know what? These folks over here probably would have come out a lot better if they had just kind of stood up. If Tex McIver could have just had some cojones and just said, listen, I made a mistake. Judge McBurney, I'm an officer of the court. I just made a mistake. This is why. Please show me some leniency. You know, if you want me to do some other stuff or whatever, I'll go do it. But please show me some leniency. Because I'm coming clean. But instead, we got 2.5 days worth of all of this to come to the conclusion that he knew about the gun all along. And did all these things in order to try to hide the fact that he knew about the gun. And I'll just say to the court, it's just not right. So I'm asking you to do something about it. I want you to let the defendant know that the rules, they apply to everybody. Everybody. And that he is not above the law. So I'm asking the court to revoke his bond. I want you to revoke his bond, and I do not say that lightly. For all the previous reasons that I've stated. And if the courts feel so inclined to impose, you know, other conditions, because the court has been privy to some other activities, you know, live streaming, and there's a whole lot going on. You know, talking between witnesses. I talk to a witness, they talk to the defense attorneys, and there's always this shield that kind of is blocking and obstructing the truth from coming out. And you got the power to do it, Judge. I know it's within your discretion to do it. I'm going to ask you to find that it's necessary to allow the fair administration of justice to occur. Thank you.
You're welcome. Bill, I need to submit one legal question to my research team that they can be working on, and then I will hear from you.
Yes, sir.
I do. One second.
Yes, sir.
I just sent her something.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, this is not where I intended to start my closing argument on behalf of my client, but I do have to make these observations. Number one, I do take issue, and I take offense at Mr. Rucker's, not an insinuation, a statement to the court that somehow the lawyers for Mr. McIver have advised witnesses not to be cooperative with the DA, or we've interfered with the DA's investigation or improperly had conversations with witnesses. That is not the fact, and there's no evidence in the record to support that. Number two, I did not object because we don't have a jury here, we have a court. And truth be told, Judge, I know you can parse through this, but I can't let it go unresponded to that Mr. Rucker took a substantial liberty in arguing facts not in the record. He argued conversations not a part of the record, and he'd offered them to the court as evidence, and I'm sure the court can parse through that. But this is where I do want to start. I want us to talk about why we're here. We're here on a motion to revoke the bond, and I believe that motion was filed on April 17, 2017. Now, if you go back and you look at the motion, and this is what I did. I looked at the motion, and the motion to revoke bond is based on the discovery by the district attorney's search team on April 14, 2017 of a black Glock in a drawer that's been called a sock drawer, and it was serial number KBU 446. That's why we're here. And this motion to revoke bond is based upon Mr. McIver's constructive possession of that firearm. They didn't find it on him. It's constructive possession in that it was in his condo. When you read the written motion on file, the basis for the motion are three. One, quote, he will commit additional felony offenses. Number two, he is a significant risk of intimidating witnesses or obstructing the administration of justice. Number three, there is a significant probability that the defendant may flee the jurisdiction. And then they conclude, quote, if permitted to remain on bond. So I am looking at and trying to ascertain the playing field and the points of engagement. And when I look at the written document on file, this is it. This is what we're talking about. Now, what we know is this, that there was a bond granted to Mr. McIver on December 22nd, 2016.
I want to help you focus a little bit. That's a fair request on your part. One, I haven't heard anything during the many hours we've been together that raises a concern on my part about Mr. McIver's risk of flight.
Yeah.
So you're welcome to address it. I didn't hear Mr. Rucker invoke that in his closing. It really hasn't been a focus of what we've been talking about.
Yes,
it is in the motion, no doubt about it. That's not something you need to read another word about if you don't want to. But I am concerned, based on what I've heard, about safety of community allegation. And I appreciate that that's not in the motion. I don't believe that prevents me from weighing that as a factor. If you think I shouldn't because it wasn't pled, and you think after these many hours you're not on notice of that, you should spend some time on that, because I think I'm entitled to consider any of the IALA factors and anything else within my discretion in assessing whether or not, first of all, Mr. McIver has violated a condition of his bond. If he hasn't, my concerns are irrelevant.
Yes, sir.
If he has violated a condition, and should I decide that he constructively possessed the gun, then we get to the so what. What do we do about it?
Yes, sir.
And what I would be working through, if I get that far, is not how is that proof of risk of flight. It's not.
Mm-hmm.
But I would be weighing what does that say about the safety of Mr. McIver and anyone who might be around him.
Yes, sir.
I wouldn't ignore that if I were you, unless you think you can point me to law that says, Judge McBurney, you ought not to consider safety to others and the community as a factor, should you conclude that a condition or conditions of the bond been violated.
I want to address it on the facts
Okay.
that are relevant to this proceeding. To take us back, December 22nd, 2016, that was a bond granted. He actually got out of jail the next day on December 23rd, 2016. That bond was modified on January 30th, 2016. And the ankle monitor was removed, and like you said, there's been no issue ever about flight. And there was a removal on the restrictions of contact, except for under his current bond, he's not to have any contact with Danny Joe Carter, who is Patricia Diane Carter. No allegation that he's violated that condition of his bond. So when we look at his current bond, by virtue of the fact there's an absence of evidence, the court has to assume that he's been in compliance with all those conditions. Now, these are the uncontested facts of this proceeding. In the four corners of this courtroom during these past few days, bond was set on December 22nd, 2016. Janie Calhoun and Phyllis Gable removed all the guns from the condo, or they searched for and attempted to remove all of the guns from the condo. That the condo possessed guns that were both Diane McIver's guns and Tex McIver's guns. That on December 24th, 2016 at the ranch, Sheriff Seals helped Mr. McIver identify, take custody of, and remove the firearms. The evidence is uncontradicted that Mr. McIver has worked to meet all compliance with the conditions of his bond, even so far as not to travel out of the state to see his 97-year-old mother because he was afraid that he might not be allowed to travel. And the court can take judicial notice of his own records. He filed a motion for clarification and modification of bond before he ever left to go see his mother. We've got the statement of Sheriff Seals. He went through the list that he used to inventory the guns in Putnam County. And we've also got the statement of Sheriff Seals that is uncontradicted, that he has never known Tex McIver to lie to him. The evidence is uncontradicted that since December 22nd, 2016, when he was released on bond and the conditions were imposed, no one has ever seen Tex McIver with a firearm. It's uncontradicted. We have a testimony from Sheriff Seals, and we have the document from the probate court in Putnam County that long before these proceedings started, he surrendered his carry license. The evidence is uncontradicted. He has never asked anyone for the return of his firearms.
Since he got his bond?
Since he's been out on bond. Since December 22nd, 2016, when his ability to be in close proximity to a firearm was substantially limited, literally reduced, he has asked no one to return a firearm to him.
No one who's testified in court?
No one who's testified in court, and the state has produced no evidence that he's attempted to purchase a firearm since December 22nd, 2016. Now, Tammy Johnson testified that she looked in that sock drawer sometimes 3 weeks earlier, and she didn't see a gun in there. She also testified that she was looking for a ring, and she went through everything. But her testimony is not in detail about what she did other than just opening the drawer. She didn't see a firearm in there. Miss Phyllis Gables, who does the laundry, her testimony is uncontradicted. She does it 3 or 4 times a week. She washes the clothes. She makes sure everything is restocked, including the sock drawer, when she leaves on Friday, so that they can always have fresh clothes, iron, pressed, put away during the weekend. Also, and this is extremely important, and I'm confident the court has taken note of it, there is an absolute absence in the record of any evidence that Tex McIver ever instructed Tammy Johnson on what to do with that gun. None. The only thing Tex McIver asked her to do was take a photograph of it and send it to Howard Seals. That's the only evidence of record. So any contention that Tex McIver has interfered with investigation or evidence is absolutely hyperbole. There's no record evidence of that. Now, with reference to this issue of surprise that Mr. Rucker claims, Mr. Rucker ain't surprised nobody. You got to be a lawyer for 6 seconds, and only 6 seconds, to be deprived of the ability to conclude that they are going to search the condo and the ranch. It's absolutely unreasonable not to assume that. There's no testimony of communications between Mr. McIver and his lawyers, and the court is aware of why there's no testimony between the counsel. But Sheriff Seals testified that he told Tex, they're going to search your condo, and they're going to search your ranch. About 3 weeks before it happened, he told Mr. McIver that. So for Mr. Rucker to contend that it was a surprise, it is not a surprise. The other uncontradicted fact of record is that the Glock was found in the box, the original purchase box, in original purchase condition with 2 empty magazines, no ammunition, in a sock drawer.
When you say original purchase condition, what do you mean by that? Because of course it's not in the right box. So it can't be quite original purchase condition. So help me understand your contention.
When I said purchase condition, I mean I open the box and there is a Glock with 2 empty magazines. It's got all the warranty information, and it's got that little speed loader, which if you've ever loaded a Glock, it will tear your thumbs up trying to get the ammunition in there. They find it in that condition. It is not in fire-ready condition. It is not. It is also not joined in the discovery with ammunition. I mean, there were no hollow points. There were no full metal jackets. They had some rat shot, and that's what they call it, rat shot. So they find this Glock in a sock drawer. They open the drawer, they're looking through the socks, and they find the black box, and they pull the black box out. Now, there's nothing on the search warrant about searching for handguns, but they found a box. It's clearly marked Glock. They've got it the way it's reasonable to assume there's a gun in it. Nonetheless, they open it. Now, there's a concern about having to get a search warrant, which I find incredible in light of the fact that they also testified to conduct that would be in violation of his right, some right to privacy, a Fourth Amendment right to a box that they are not searching for a weapon. But be that as it may, they find it in a sock drawer. Let me tell you where they do not find it. They don't find it in any of the 2 safes that Tammy Johnson had to use the combination to open for them to get into. If Mr. McIver was trying to secret that gun, it wouldn't have been in a sock drawer under some white socks.
Unless he thought there was going to be a search warrant executed, in which case they're going to search my safe. Why are they going to search my sock drawer if they're looking for documents?
If they're going to, the reasonable assumption is if they're going to search my condo, they're going to turn it upside down. They are certainly going to pull open a sock drawer. If I want to secret it, I'm going to put it in a safe. It's not in a safe. It's in the bottom of the sock drawer. Bottom of a sock drawer that Ms. Gable says she's in and out of that drawer all the time and she didn't see it. And Ms. Johnson testified that with reference to that drawer, she didn't see it. Now, we spent a substantial amount of time on testimony from witnesses about telephone calls. And, Your Honor, from my perspective, this entire exercise, a substantial amount of it, has been an exercise in misdirection and gamesmanship. How many times people called each other and how long those telephone calls last are neither here nor there. What is of importance is the substance of the phone calls. And we got into evidence the substance of the telephone calls. Now, the problem is the district attorney's office doesn't like the substance of the telephone calls. What they were hoping is they found a telephone call during which Mr. McIver instructed someone to do something with a weapon. No matter what he instructed them to do, they would contend that it constituted a violation of law. Mr. McIver never instructed anybody to remove anything, to secret anything, to transport anything. That was never a conversation that was had. The other thing,
you're basing this on Ms. Johnson. I mean, obviously, Mr. McIver hasn't testified. Fine, doesn't need to. We have Ms. Johnson, whose testimony was intriguing and rather inconsistent with the testimony of others. So when you're asking me to rely on the evidence as to what Ms. Johnson discussed with Mr. McIver, you're asking me to rely on Ms. Johnson's testimony, unless you've got another angle I'm missing.
No, and the fact of the matter is, whether you rely on Ms. Johnson's testimony or not, there is no evidence of a record that Tex McIver instructed anyone to move this weapon. There's none. You can either rely on Ms. Johnson's testimony, which is Tex never told me to take this weapon, out of the condo or remove it, or you can disregard Ms. Johnson's testimony. Now there's an absolute absence in the record of any testimony regarding any conversation with Tex McIver concerning this weapon.
So you're saying that if I choose not to credit Ms. Johnson's testimony, for
Yes.
example, she's asked, did Mr. McIver tell you to do something with the gun? No, he didn't.
Yes.
And I find that not to be credible, then I'm left with not he did, but no evidence.
Because you cannot assume that he told her that. There's no evidence.
But there are two answers to the question, he did or he didn't. And if I find he didn't not to be credible, then how is it that I'm left with then no evidence? The question wasn't, what did you talk about? On more than one occasion, I believe Ms. Johnson was asked, did Mr. McIver tell you to move the gun?
Yes.
No, he didn't.
Yes.
And if I elect not to credit Ms. Johnson's testimony for any number of reasons, you're saying that the proper evidentiary ruling on my part would be, then there is no evidence as to what Mr. McIver said about moving the gun,
Yes.
or wiping it down, or whatever.
Yes, because if you disregard her, you have no factual basis for the inference you want to draw, because it would be inferential that he must have told her to move it. But there's absolutely no factual predicate for it.
But the difference between disregard and find not to be credible, and if you, I'm not trying to
Yes,
wrestle with
I understand.
I've not had to deal with this before, because usually a jury has to. But the question was, did he tell you to move it? No, he didn't. Not I don't remember. Not he may have, I'm not sure. No, he didn't. And if I find that not to be credible, you're saying then it should be disregarded and there's no evidence, as opposed to not credible as in the other thing then must be true, he did.
Because in this context,
Because then you could, I'm sorry to interrupt, but then you could lie, not saying she did, but you could lie and then prevent any fact finder from deciding actually it was the other way around. It was this perfect shield you could build around someone. But, well, I'll just lie. I may get in trouble later on, but the fact finder can't ever conclude from what may be demonstrated to be not credible that the opposite is true.
and in that situation, what you do is you impeach a witness to show his or her testimony to be unbelievable. And you have to have some evidentiary support for the other inference you want the jury to draw. In this situation, the uncontradicted testimony of record is this. Tammy Johnson testified she had a conversation with Tex McIver. He said, photograph the weapon and send it to Sheriff Seals. Did he ask you to move it? No. Did he ask you to do anything else with it? No. Uncontradicted. No one else has testified they ever had a conversation with Tex McIver about moving this weapon. So the only evidence of record is he didn't tell me to do anything with it. So if you disregard her testimony, you're left with no evidence of record. And I would suggest it would be improper to draw an inference at first to Mr. McIver from no evidence of record.
Okay.
So with reference to these telephone calls, obviously the district attorney was hoping to find some evidentiary support for their representation that Mr. McIver has interfered with some witness. There is no evidence of that. They've complained about Mr. Maples' representation, Mr. Maples' directive to Ms. Johnson that she simply take the weapon and take it next door to Janie Calhoun, which we've learned during the development of evidence was very reasonable in light of that's where all the other weapons are. That makes sense. Now, what we don't have is evidence of a telephone call from Ms. Calhoun, Ms. Johnson back to Mr. Maples after Ms. Calhoun refused to take the weapon. But there's no evidence that anyone attempted to interfere with an investigation or a search by the district attorney's office. The other thing that is extremely enlightening in this case is that there were multiple individuals on this search team in that condo. Ms. Johnson was there during the entire search. And there was conversation constantly between Mr. Rucker and Ms. Johnson. And the fact of the matter is, Mr. Rucker made substantial use of her presence, asking her where documents, how do I find this, where is that, come open this safe, come open that safe, brings her in as a verification that they found a Glock in a sock drawer, literally told her, why don't you take a photograph of it too? There's a purpose behind that. What is absent is any instructions from the district attorney specifically about this Glock. Now, at some point, Mr. Abate evidently said, "Don't you get involved." No explanation as to what that means. Nobody instructed her, leave this here, don't move it. They certainly can't instruct her, don't talk to anybody about it. But they give her no guiding instructions with reference to this Glock. That's curious to me. They didn't take it. They could have taken it, and I listened very closely to Mr. Rucker's closing argument. He didn't describe the possession, the constructive possession by Mr. McIver of this Glock as a violation of a law or a felony. He described it as the violation of a court order, as contempt. So if it was a violation of a court order, he did what he was supposed to do, which was take a photograph of it, but he could have taken it. But he didn't take it. And I'm going to tell you why he didn't take it. He didn't take it because he was hoping Mr. McIver would come back to his condo. Now, Mr. McIver is not only in constructive possession, he's in actual possession because they have found this weapon. They have made sure that Tammy Johnson saw the weapon. They made sure that Tammy Johnson took a photograph of the weapon so that they could argue vehemently that it is unreasonable to conclude that Mr. McIver didn't know it was there, and he put himself in close proximity such that now he has actual possession. That is a great way to try to revoke his bond. That was why they left that weapon in the condo, and that's why they didn't come back until the next week to look for the weapon. It was not by happenstance, it was by design, and it's gamesmanship, and that is not the way this ought to be done. Additionally, these proceedings have been elongated, Your Honor. We've been here for a number of days. And the court is aware from the very first day I have asked Mr. Rucker to share with me the ATF trace report so we can truncate this. What I learned on yesterday was that Mr. Rucker obtained a copy of that trace report on the 19th, because it's dated April 19th. So he's had this document for a long period of time. He's not shared it with us. So he's forced us through this entire episode and this entire endeavor. But the benefit of it is this. For my client, it gave us an opportunity to hopefully present to the court evidence of Mr. McIver's, I contend, Herculean efforts to comply with his bond conditions. If Mr. Rucker had shared the ATF trace report with me early on, we could have truncated this and we'd have come directly to the point. Otherwise, and this is what he did, he forced us to run down every possible explanation for the possession of this gun, and that's what we did. There is absolutely no record evidence. It's not on any list that this Glock found in the sock drawer was purchased by Mr. McIver. There's a reason why. He didn't buy it. There's no record evidence that Diane McIver purchased it because she didn't buy it. You can't, it's unreasonable to expect an individual to remember every purchase he made. So here we are with the weapon, and we can't ascertain ownership, but the DA's office can. They won't give us information on ownership, so they force us to present all of this evidence. And what we've done is we've had an opportunity to present to the court every reasonable explanation that was available to us at the time. But it also gave us an opportunity to bring in witnesses for you to hear. And those witnesses testified to Mr. McIver's efforts to comply with his bond, the effect on him emotionally and psychologically when he was told that this weapon was found. All of those witnesses testified to you, and their testimony is uncontradicted by the district attorney, that Mr. McIver's responses were genuine, they were heartfelt, he was shocked, and he was scared to death after that weapon was found that his bond would be violated. And, Your Honor, that is evidence of his attempts to comply. So when Mr. Rucker argues that he cavalierly regarded his obligations under the bond, all of the record evidence is to the contrary. Now, the court is well aware that the purpose of bond, especially in a judicial system like us, here in Georgia where there's a presumption of innocence, bond is not to be set so as to be punitive in nature. And bond is to protect the individual until such time he's found guilty of a crime, then he loses his presumption of innocence. And the whole matrix changes. But as we sit here today, Mr. McIver is an innocent man charged with criminal offenses. And I know the district attorney takes issue with this, but this is a horrendously devastating accident. And if for a moment you would afford Mr. McIver the presumption of innocence, this man suffers. I mean, he really does. I can't imagine what it's like at 1 o'clock in the morning in your condo by yourself. And the only thing you can think of is that I did something that caused the death of my wife. And not only is he trying to deal with that, now we have to deal with the district attorney at every single opportunity, taking every run at Mr. McIver that they can to revoke bond. This is not the first time, and it won't be the last time. If the court continues him on bond, they'll be back again. And I'll tell you, Your Honor, if you look at this case the way it should be looked at, and I'm glad I don't have to spend any time on attendance because he has been at every court appearance. But this issue of protection of the public and whether or not he constitutes a continuing threat, for him, his restrictions on conduct began on December 22nd, 2016. He gets a piece of paper that says you can no longer do this, 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 and this. On December 22nd, 2016, he absolutely alters his conduct. He does everything on that piece of paper he is supposed to do, and he does nothing on that piece of paper he is precluded from doing. So the appropriate scope of inquiry here for Mr. McIver on this bond hearing, his universe for this court ought to start on December 22nd, 2016. What has he done since that date that constitutes a danger to the public, that constitutes a flight risk? Has he contacted anybody for whom he's been excluded contact? No, he has not. Since December 22nd, 2016, he's done everything he's supposed to do. The uncontradicted testimony is that 3 women went through that condo. They went through it right after Ms. McIver's death because they wanted to clean it of all firearms before Mr. McIver got home that Monday afternoon. They collected every firearm they could and they took it next door. The testimony is that at some point, Tex said, you know, just bring the guns back. Then they bring Mr. McIver in. Actually, he surrenders voluntarily. He's bonded out. He surrenders on the 20th. He gets out on the 20th. Well, actually, he surrenders on the 21st. He bonds out on the 22nd, but he doesn't leave jail until the 23rd. Those ladies go back through that condo, and they take every gun they can find. And everybody is shocked and surprised that a gun was found in that sock drawer because they believe in their heart of hearts they had found every weapon. And Mr. McIver believed in his heart of heart they had done a good job. The day after he gets out, on the 23rd, he gets in the car and goes to Putnam County. So he and the sheriff can go through the ranch and collect every firearm. So this is a man trying to get rid of all the guns because he does not want to have his bond revoked. So when we look at what he's done, he's done everything he could to comply with his bond. And I'm a realist. I know where we are is this. There is ample evidence for this court to find beyond a reasonable doubt that a firearm was in his condo, and he's in constructive possession of it. If Mr. Rucker had been above board and honest with us, as I asked him on numerous occasions, that's where we could have started from, and we could have had this discussion. He put us in a position where we had to call all these witnesses, and we had to try to run down all these rabbit trails because we didn't know who this weapon belonged to. So we find ourselves here. Mr. Rucker dangerously overstates the state's position on this. Mr. McIver is not a threat to the public. He's a 74-year-old man. Truth be told, he can't survive in jail. He can't. And so for us, this is an extremely important hearing. I'm not a novice at this, and I don't have a hard time reading the tea leaves. And Judge, I'm going to tell you what's going on. Mr. McIver is not charged with murder. He's charged with involuntary manslaughter. That's an unintentional shooting. He's charged with a misdemeanor offense, which is reckless conduct. There's no evidence to support a prosecution on involuntary manslaughter. There's not. This is the name of the game. Get him in jail. Once we get him in jail, let's slow up. Let's let him ripen for a little time. Let him sit there 6 months, 9 months, 12 months, 18 months. He'll plead to anything. Judge, that's where we are. And that's what this is all about. And that is not the way bond is supposed to be used. It's not to be used to leverage a guilty plea. So what do I expect? Your Honor, quite frankly, I expect the court to find the evidence in such that there's a violation of bond. He was in constructive possession of a firearm. But once you make that evidentiary finding, then this court is possessed of substantial discretion on the other side as far as what is the appropriate sanction to be imposed. Now, Mr. Rucker asked for the most draconian sanction available, which is to violate his bond and put him in jail. And Your Honor, that is not warranted by the facts and the circumstances. There is no evidence that Mr. McIver has been cavalier in his responsibilities under his bond. The evidence is that he has been substantial in his efforts to comply. They've got one thing. They found a weapon in his sock drawer that nobody discovered, that nobody knew was there. And we asked who did it belong to, and they wouldn't tell us. And they made us come in and put up all of this evidence as they sat there with the ATF trace report through this entire hearing. That is not the way this process is supposed to work. It's supposed to be an exercise in trying to find the truth and justice, not gamesmanship. And we've been absolutely above board with the district attorney, and we have gotten nothing in response. I even talked to you about the difficulty in trying to get them to acknowledge service of a civil complaint. So, Your Honor, what we ask is this, is that the court allow Mr. McIver to continue on bond. If the court is inclined to impose some sanction on Mr. McIver, we would ask that that sanction not have as any component that he report to confinement. He does not deserve that. He has tried too hard to comply to be put in jail. If the court is inclined to continue him on bond but impose some additional conditions, we would like to have a discussion with the court and make some suggestions as to what they should be. And, Your Honor, I'd have to ask that the court seriously consider allowing us, before ruling, if the court is inclined to impose any period of confinement, to give us an opportunity to have a forensic psychiatric evaluation done of Mr. McIver, and we will share that with the district attorney's office, and we will share it with the court. Where we are is this. You have in front of you a defendant who is charged with an unintentional crime that has had horrendous emotional and personal impact on him, and the district attorney is trying to leverage him into a plea that there's no evidence to support. And they're asking for the most draconian sanction where there is no evidence that he has accosted any member of the public, that he has assaulted any member of the public. There is no evidence that since he's been released on bond on December 22nd, 2016, he has been anything other than a model citizen. And we would ask, Your Honor, that you continue Mr. McIver on bond, and if the court is inclined to do anything other than that, we'd like to have an opportunity to discuss with the court some alternatives, and if possible, a forensic psychiatric evaluation. And I offer to the court that this is a very, very sad situation we're in. We've got a 74-year-old man who is presumed to be innocent, who has lost his wife in a tragic event, and they want to put him in jail and let him ripen until he'll plead to anything. And that is not the way this is supposed to work. Thank you, Your Honor.
You're welcome. I appreciate your thoughts. Mr. Rucker, if you have any couple minutes you want to say in response,
just a couple of minutes.
I feel like this is balanced. I don't need to hear a whole lot, but
Right.
If there's something you want to say, I'm happy to hear from you since you bear the burden.
Okay, yes, sir. And I'll just touch on just a couple of things. I'm not going to go back and talk about everything that Mr. Hill addressed, but I'd like to direct the court to a case. It's Cantrell versus the state. The site, Your Honor, is 204 Georgia Appeals 330. It's a 1992 case, and it stands for the proposition of factually a warrant was obtained to search an apartment located in Gainesville, Georgia. And during the course of the search, in the dresser drawers, they found a .25 caliber semi-automatic handgun. And what the court found was that with the proper execution of the search warrant, that the court is authorized to find the, in this case, the appellant, but it would be the defendant, as the analogy, would be in constructive possession of the gun that was found in the dresser drawer. And so I say to the court, I heard Mr. Hill kind of say, oh, well, you know, what the DA did was we were trying to set up Mr. McIver because we left the gun so that he would come back and have actual possession of it, and aha, we kind of bust him. It's so incredulous, but I just had to just kind of tell you, like, really, if that's what we were going to do, like, folks would have been waiting in the lobby for him to come home, and like, as soon as he went upstairs, like, we come in with the warrant and we get it. But instead, what we did was, like Investigator Griffin said, it was incredulous for her to believe that Tammy Johnson would move this gun. And so we came back on Monday and got a warrant and went back to the condo, and the gun was gone. That doesn't sound to me like a real good plan to kind of bust the defendant in actual possession of the gun that was seen on a Friday. Let me tell you one other thing, too. I was listening very carefully for Mr. Hill to give us an explanation about how this gun got in the drawer. Just kind of some explanation about how the gun got in the drawer. I wanted to see if they were going to put it on Phyllis or put it on Tammy or put it on somebody. How did the gun get in the drawer? And like, he's silent on that. Silent on it. And it's really, really important because kind of what he said, and I wrote it down, he said that the gun was found in a sock drawer that nobody had found before. And he represents to the court that these women were just searching and searching and searching, and they just never seen it. And so I guess on this day, it magically, like, I don't know, metastasized just out of just thin air and appeared underneath all these socks in the drawer. And this is what we know. I took some great pains to do it because it's just common sense. It's just breadcrumbs. So, like, you got a picture of the same socks in the drawer, like on the man's tennis shoes in the bedroom. You got witnesses who say, yeah, the man works out 3-4 times a week. I would assume that was the week in question where we searched his house. He uses the white gym socks. He would go in the drawer. We got testimony from a bunch of folks that, yeah, he wears white socks every time he wears boots. He wears boots all the time, 3-4 times a week. It's incredulous to believe that he doesn't go in that drawer all the time. And it would not put that gun in a safe, because that is exactly where I would be looking to find some important documents. And everybody knew I was looking for important documents because it's the matter of public record. We've had conversations with the defense attorneys about it. And so, yeah, where would you put it? You'd put it somewhere you wouldn't think somebody would look for documents, which would be like in your sock drawer. Now, I want to tell the court that, and I know you know this, he is charged by the Atlanta Police Department with involuntary manslaughter that has absolutely nothing to do with the Fulton County DA's office is going to do. Nothing whatsoever. And so I do appreciate the fact that he is presumed innocent at this point, but there's no reason for me to leverage somehow those charges into a guilty plea by wanting to put him in jail, because I think everybody in this room knows that pretty much taking pleas on murder cases, that's not what I do. I go to trial on cases, and I fully expect to go to trial on this one. I think the testimony was that Ms. Johnson actually said to Mr. Abadi that she didn't believe the defendant was coming back to the condo on Friday. I know that because, I was there. It was a concern, which is why Mr. Abadi said to her, hey, stay out of it, right? We asked, where is Mr. McIver? I think he is in Putnam County. That's what we believed until we get Janie Calhoun on the stand and she says, oh no, he's in Atlanta at a ball game for Austin, which means he was in town. Wearing his tennis shoes with his white gym socks, taken from the same drawer where we found this gun. The defendant suffers, that's what Mr. Hill said, but he still loves them guns. That's why he asked Janie Calhoun to give them back to him. And this whole thing about a psychiatric evaluation, they never brought that up before in order to get him a bond. Ain't no evidence that he got some mental issues. He knows what he's doing. He knows exactly what he is doing. He didn't have no problems communicating on the phone on Friday night. And this is this is one of those defense kind of arguments. You know, they say, well, Tex, there's no evidence, Judge, that Tex actually told anybody to move the gun. This is what Tex did on Friday that we know from Janie Calhoun. When he found out that the gun was found in his sock drawer, he said, hey, y'all call Howard Seal and see what he says about whether Tammy can move the gun. Because Tammy was concerned because she didn't have a permit. I know you remember this. She didn't have a permit. She was worried about carrying the gun and whether or not she could be charged with a crime. He knew that the gun was going to be moved. Who put that in motion? He did. He did. He could have said, hey, y'all put that gun back. Let me have my lawyer call the DA. Did they give you a number? We're going to get this straightened out right now. He could have done that, but he didn't. That's what he should have done. He's a lawyer, for Christ's sakes. He knows better. Our profession means something. It's an accident. The court asked him to address the safety to the community. We know that the contention, this is what Mr. Hill just said, it's an accident. Terrible accident. The gun that killed Diane McIver, it just went off. Accidentally, just boom, it's a bunch of malarkey. And what we know from the little short testimony you have from the gun expert in here, guns don't just go off. You got to pull the trigger. And it was Diane McIver that time, shooting out at buzzards another time. We don't know what we're going to have happen in the future. And I'm asking you to not allow us the unfortunate experience of maybe finding out because somebody else gets injured. I want to blame everybody, Mr. Corey and James Hugh. They want to blame the women for not finding the gun in the sock drawer. He used the drawer every day. Okay. I think I'm through, Judge. And I again just reiterate, I'm going to ask you just to find that the defendant has violated his condition of bond. I want you to revoke him and allow the fair administration of justice to move forward with respect to the investigation in this case and prevent the further influencing of witnesses and tampering with evidence. I just want to thank the court for its time because I know you worked hard to get us in.
Okay. I'll be back before 4:30, and I'll let you know what we're going to do.
Thank you, Your Honor.